this is a proposal. The reference offer is in the hands of the gatekeeper. It's a different system than industry-wide standard or interoperability. So what the gatekeeper might propose in 2 months, 1.5, has an impact in whether the offer is interesting for the user, for the access seeker to take.
We have discussed just before the break the process, the compliance process. Now we will go to some specific obligation or group of obligation. And so there are 3 issue paper in the DMA report that we have published. The first is on data-related obligation, and Giorgio will discuss that, that paper. Then there is one on interoperability, vertical and horizontal, and Marc Bourreau will discuss that one. That is for this panel, and then in the next and last panel, we will discuss the paper on choice architecture that Amelia will present. So in this panel, so we have 2 groups of obligation, if you want. First there will be a presentation by Giorgio and then by Marc, and then we have a number of panelists. We have, and I will start with Chris Rayleigh, who is the Executive Director of the Data Transfer Initiative, so which is an interesting initiative to help some of the data-related obligation of the DMA. Then we have Audrey Scozzaro, she's at Qualcomm. Then we have Daniel Friedlaender at CCIA. Then we have Chiara Caccinelli. She's at Arcep, the French telecom regulator, but she has also she's also very active in BEREC, and so in that sense on interoperability. And finally, we will have Filomena Chirico from the Commission, and she will react on what she has heard by the panelists. Okay? So, Giorgio, the floor is yours.
Okay, thank you. So in this paper, we're looking at 3 data-related obligations that are found in the DMA. For each of them, we've analyzed the purpose, the main challenges to implementation, and the links to the EU rules. Very briefly, in terms of purposes, we think all 3 sets of obligations, the data fusion, the so-called data silos, and the data portability rules, are all about facilitating contestability at different levels of the market. In terms of linking to other rules, I think the main message of our report is to say this is not GDPR plus, it's not an enhancement of personal protection, it's an enhancement of data rights for contestability and fairness purposes, and not to see this as an instrument that aids the enforcement of general data protection rules. I'm going to turn now to the main challenges faced in each of the sets of obligations. So first of all, in terms of the data fusion and consent, we detected in the DMA a preference for a particular model for implementing this obligation, which is to offer the users a choice between a personalized service with data collection and then a less personalized service without data collection, and allowing the user to actively make that choice, knowing the consequences of the 2 choices. Now, we think there are sort of 3 challenges that are to be faced in implementing this. The first is sort of how to implement consent. And here the DMA adds to the requirements of the GDPR. In particular, it adds a clause about dark patterns. It regulates the frequency at which consent can be given, and also gives the user who denies consent the right to continue to receive the the less personalized version. And so there is no punishment for the end user not choosing to have their data collected. I think another difficulty is if the gatekeeper is obliged to provide a less personalized but equivalent service, what does that actually mean in practice? And we worked through a couple of examples to suggest that this is not particularly easy to work out. And then finally, and this is a point I will park for Amelia Fletcher to discuss more fully in the next panel, how to design user choice effectively. And I think there are trade-offs here between having a very easy to understand proposition, choose A or B, which the user can easily get, but maybe doesn't allow the user to make a precise choice, and a very granular option for the user to use, which the user may not understand, and although it looks very good on paper, it actually doesn't allow the user to make a good choice. So how to engage the user effectively by some sort of simplified heuristic so that the user can actually make an effective choice is going to be, I think, quite difficult. However, I don't think this is the only way to comply. You cannot tell the gatekeeper the only way to comply is to offer these two options, and that's it. So I think there can be more alternatives, and what we explore in the paper is a little bit what other alternatives are there to allow the gatekeeper to comply with 5.2. Can they offer a take it or leave it option? You either use the service and have your data collected, or you don't use the service. Can they make the service paid for if you don't agree to data collection? Can the gatekeeper buy the user's data? After all, the data is the commodity that is being given by the consumer to the gatekeeper that is monetized, so perhaps the payments should go the other way. But perhaps what is most realistic is to expect the gatekeeper to provide a variety of less personalized services. That is to say, the user can choose which data can be transferred to the gatekeeper for what purposes. A user may well be happy for some of the data to be transferred for some purposes, but less happy to have it transferred for others. But of course, this makes the choice screen even more complicated, because then there's just a choice between data and no data, but it's a choice which data, and how can the user be empowered to understand which kind of options they're going to make choices about. And this goes back to a general point about the DMA, which is we do want end users to be active, but the question is who provides for the literacy for them to be sufficiently informed when they are being active. So whilst the DMA can be praised for encouraging an active user experience by the end user, it's also perhaps something for policymakers to think about. How do you make sure that consumers make these choices in an informed way, and are they sufficiently literate to make these choices? The other point on 5.2, very briefly, is that there are other bases for data fusion, but I think if we read the DMA together with the meta judgment, you see that the opportunity for using these, although there, is relatively limited. So we think implementation will really hinge about whether the consent moment that the end user is exposed to will be sufficiently effective to comply with the DMA. If I move to Article 6.2, which is about the limiting of the exploitation of business user data by the core platform services. A couple of preliminary points in terms of implementation. Does this apply to all gatekeepers offering all services? In the report, we suggest that for some gatekeepers it is clearly applicable, but for some others we raise questions as to whether this obligation is really for them. The other thing to notice is that although the word data silo is now more or less common currency, and so there's no escaping it, that is a bit of a misleading label, because what we are prohibiting is the specific use of certain data is siloed. So it's not that data as a whole cannot be used for anything. This data, which is not publicly available, must be siloed for these purposes. And this matters when it comes to compliance, because then we need to decide which data first, but also which purposes are to be siloed, so that the data can move around the company for certain purposes and not for others. And therefore, in terms of implementing the design of this, it's very important to have an appropriate process by which the data is siloed for the reasons that it is prohibited, but is also freely available for the corporation for others. And we think a good lesson for how to think about effective implementation is to look at some merger decisions. And I think Google Fitbit, the commitments there suggest the kind of implementation that we could potentially see in the context of the DMA. Just to highlight a few things, a lot of the commitment is about defining data, defining and documenting who has access to that data, providing processes to test whether there is a data failure, providing processes to prevent circumvention, and then really empowering in the merger regulation, it's different, but here empowering the compliance officer with an oversight role to see whether or not the system that has been put in place is sufficiently robust. So this is one where I think process-driven compliance is going to be perhaps more important than sort of outcome-based compliance. It'll be difficult to see what the outcomes are of this. But I think there are lessons from the merger regulation that allow us to see the kinds of things we should expect from implementation of this obligation under the DMA. And finally, on data portability, I treat the two provisions similarly. We have a few general principles that animate the discussion: effectiveness, proportionality, which we've discussed, participation, and also non-discrimination as a general principles to inform the implementation of this obligation. I think the greatest trade-off here, or the greatest challenge in implementing data portability, is between giving access to data versus protecting the privacy and security of the user. And to a certain extent, when third parties are handed the data of the user, then we need to determine a little bit how secure is that data in the hands of the third party, and who is the one to determine who the third party is that is sufficiently secure, and how do we certify that the third party can be trusted. And again here, to a certain extent, empowering the end user to make this choice also requires them to trust the system. And so one corollary to empowerment is to have a system which is sufficiently robust that allows the users to feel that, yes, I am consenting to my data being transferred to a third party whom I can trust, and that there's a verification mechanism that the user can then confidently make that choice. And to a certain extent here, the last point I want to make is the importance of participation in shaping this obligation. So this is one of those obligations which I think will be more of a process than an immediate outcome on March 7, because to a certain extent, a set of agreements will have to be made in terms of technical standards for approving third parties to process the data. And so it may be that rather than, whilst I think with Article 6.2 we can think about a discrete event, here is my plan for compliance, with the data portability, I think compliance will be more of a process than just a one-off compliance. So it will be a short-term solution and a more longer-term coming later. And I'll stop there. Thanks.
Thank you very much, Giorgio. Now maybe Marc, if you can come on the floor. So Marc wrote that report with Jan Krämer, who is online, because he had to teach and meet his president this morning, so he couldn't make it. But he's online with us, and so he will intervene in the debate afterwards.
Le pointeur, il est où? C'est ça, non? Oui. Ah, okay. Okay, so thank you. Good afternoon, everyone. So I'm going to discuss this issue paper with Jan Krämer, which discusses some key issues and trade-offs that may arise from the implementation of the horizontal and vertical interoperability obligations in the DMA. So let's start with horizontal interoperability. So horizontal interoperability is discussed in Article 7 of the DMA, as you all know, and it concerns the so-called number independent interpersonal communication services, so the NICs, and currently WhatsApp and Facebook Messenger have been designated, and iMessage may be designated later. So horizontal interoperability concerns only basic functionalities of the service, like text messaging, but not all, and in the future more functionalities. It is to be provided upon request of the access seekers, or the potential access seekers, and be free of charge. So first topic that we discuss in the report, the first issue that we discuss in the report is how consent, user consent should be managed. So users, when interoperability is implemented, may be asked whether they accept to be discoverable on the services that they are using, but by other users of other services. And so the question here, first question, is whether it should be an opt-in regime where users obviously accept to be discoverable, or whether it should be an opt-out regime. And in the report, what we argue is that for reasons of privacy and reasons of transparency also, an opt-in regime should be favored, and then we propose a practical solution to implement that. So a second aspect of consent that may be relevant for users is consent for interoperable communication. So when I receive a call from the outside through interoperability, should I give consent to accept this call or not? So some services do that right now. So what we argue in the report is that whether we introduce such kind of consent may depend on how the consent for discoverability is implemented. So if there is a clear consent from the users to be discoverable, maybe we can take it for granted that they accept interoperable communications. So this is it. And nonetheless, so then what we discuss in the paper is also that there are some key technical challenges for the gatekeepers and the third parties to make interoperability functional. So a first technical challenge concerns what I've discussed, that is user discoverability or identity discoverability. So how technically users can be discoverable across networks. And here there is no easy solution, and whatever the approach that is taken, there should be probably some level of standardization needed. So the second technical challenge concerns protocol interoperability, and here the technical problem is to make communications across networks as secure as they are right now within networks, in particular in terms of end-to-end encryption. And the problem is that different networks today may use different and incompatible protocols for end-to-end encryption, making it complicated to implement interoperable secure communications right now. And the third technical challenge that is to be fixed and solved is how to implement abuse prevention. So when there are malicious actors that, for example, spam others or try to lure people into buying things, so how can it be managed? So it's relatively complex right now, even in centralized systems. But with interoperability, we'll have decentralized independent systems, and abuse prevention will be even more complex. And these technical challenges, they raise a number of trade-offs that I'm going to discuss now. So the first one is between standardization and API. So the development of standardized application protocol interfaces, APIs, for interoperability versus the use of proprietary APIs by each gatekeeper that has been designated. So we believe there are strong benefits to standardization because it's going to reduce the cost of interoperability for all market players. And also what we argue when we discuss the technical challenges is that probably to fix some of these challenges, some level of standardization is in any way indispensable. So anyway, so we may think that standardization is unlikely to result from the gatekeepers themselves. But in the DMA, so there is this Article 48, which opens the door that the Commission could perhaps push for standardization. And then we conclude by some open questions, so about when the Commission could indeed invoke Article 48 to push for standardization of interoperability, and how the standardization process should be organized between the different players. The second trade-off is between APIs, between security and privacy. So there are two key objectives in Article 7. One is to protect privacy, and the other one, which is to protect security. And what we argue is that these two objectives are a little bit at odds, because, for example, to protect security, so for example, to implement end-to-end encryption for interoperable systems, then some level of exchange of metadata of users seems necessary, and it's the same for abuse prevention. So there's going to be a trade-off. So either privacy is reduced or security is reduced, but it seems not achievable to maintain the level of security while protecting privacy as the article is envisaging. So a follow-up question is whether actually the gatekeepers themselves could use this kind of inconsistency to invoke Article 7.9 to reject interoperability on the grounds that it would damage the integrity, the security of their networks, or reduce the privacy of users. Last question or trade-off that we discuss is the role of choice, architecture, and interface design, which is developed in the paper by Amelia Fletcher in the book. But we think that it plays also a key role for interoperability, because at the end of the day, interoperability is a provision that aims at increasing the choice set for the consumers. And so it's going to be key how the choice set is provided to the users. And because it's going to have implications on how easy and useful consumers see the interoperability provisions. So let me move now to vertical interoperability. So vertical interoperability, it's two main obligations for us. It's Article 6.4 about side loading of apps and third-party app stores, and Article 6.7 about access to essential functionalities of operating systems. So, whereas Article 7 is quite restrictive in a sense, so it applies only to NICs, Article 6.4 and Article 6.7 actually is very wide and open-ended, so it applies to almost everything we can think of. The idea is that there should be some kind of bottleneck resource to which there should be access. So what we do in the report is we do something which is different than for horizontal interoperability. So we discuss some kind of overarching principles that should apply to vertical interoperability. And why we do so? Because right now it's hard to find a specific example of vertical interoperability in terms of Article 6.7 that we could really focus on and then detail, and therefore we take a more general approach also for the report. And so we have 5 principles. The first one of them is that there should be some kind of screening of access requests. So not all access requests should be accepted. So obviously what we argue is that access to an essential functionality should be provided only to the extent that actually the gatekeeper itself uses that functionality. But vertical integration is necessary, but not sufficient, nonetheless. And so the question is, are the features really essential for the third parties? And here what we argue is that to use some kind of economies of scope, there is this 3 criteria test in telecommunications regulations, and we think it could be a useful approach here. The second step is to screen access seekers, so not only access requests. And why is it so? Because there could be some players that may endanger the hardware or software systems of the gatekeepers, and the gatekeepers are allowed to take the necessary measures to protect that. And we think one approach to meet this goal is to let gatekeepers grant and possibly revoke access licenses based on objective criteria. So a third principle is about who should define and manage the interfaces. And here, to be quick, so what we argue is that because the gatekeepers know the technology better, they should be the one defining and managing the interfaces. But we think that standardization should play a role, so perhaps in the longer term, and should be developed whenever possible. Access to the essential features should be provided with terms that are consistent with the equivalence of input principle, meaning that they should be provided on the same terms as the terms for when the gatekeeper themselves use the same functionality. And finally, the 5th principle is to have a neutral choice architecture. Again, so choice at the end of the day is going to be critical here in the success of this provision, and therefore it should play a key role. And we argue that all these 5 principles are not to take into silos, but they are interdependent, and so it depends. So the assessment should be done with all principles in mind. So thank you very much.
Thank you. Thank you very much, Marc. So now we will discuss. So as I said, we have 2 groups of obligation, and so the speaker is speak about what you want, but ideally you no more than 3 minutes. So I will start with you, Chris. So you have this interesting initiative, so on the data transfer initiative. So if you can just explain a little bit what you are doing and where you are there, and then also one thing you like and one thing you like less in the report. I guess it will be the data-related obligation that you will talk about, but it's up to you.
Thank you. Yes, I'm Chris Riley. I'm Executive Director of the Data Transfer Initiative. It's a relatively new organization, so just a little bit on who we are so you understand the context we're coming from. And I got this from the Monti paper, actually, a nice framing of the goal of the DMA as helping markets be more effective, putting users in control, and encouraging innovation by gatekeepers and by other parties to create a level playing field in the space. We're working towards those same goals at DTI. Our mission is to build a vibrant data transfer ecosystem. We want users not to feel trapped by their own data and more empowered to be able to use it in places and where they see fit. We have a two-part work stream. The first is building open source technologies and shared data models to support data transfers. And the second is to serve as a resource building on that expertise for policy efforts related to portability. In both of these, we work together with partners from all stakeholder groups, large industry, small industry, civil society, and government to realize these missions and to deliver our substance. So I will be very quick, but I'm going to give two broad things. One broad thing I like, one narrow thing I like, one narrow thing I dislike, and one broader thing. For both of the papers, I would say the breadth and the pragmatism of the analysis of realistic implementation pathways, I think is the real strength. I think these are the goals of the papers, and I think they delivered on them quite well. One specific thing that I very much like was from the Monti paper on 6.9, the language about trust and third parties. A quote I wrote down in my notes here, "It is key that the authorized third party receiving the user's data under Article 6.9 can be trusted and must adhere to the GDPR and adequately protect the data in their respective systems." This is an exercise that we're working on at DTI right now, how we can gather parties together and build something like a trust framework. How can we build a shared understanding of what kinds of questions can be asked, what kinds of evidence can be gathered and submitted to arrive at this outcome in a mutually acceptable way without rebuilding in gatekeeper controls and limitations that could otherwise impede portability. One more narrow thing that I read actually in the Bourreau and Krämer paper, if you don't mind me speaking to both, I'm not sure that I understand how discoverability is used in that. I'd love to hear a little bit more when we get to that. But discoverability, from my perspective, when you think about a messaging service, I don't search for people on WhatsApp. I connect with them only when I already know who they are, and I think there are sort of different pathways in there. And then a broader thing that I would say I dislike is less dislike and more a place where I felt both papers, but particularly the Monti paper, could have gone a bit further in that goal of pursuing pragmatism. It's really hard to get to standards. So the practical work of sort of understanding and arriving at a shared articulation of what data must be transferred in order to effectuate a user's intent to migrate their data, and then building the adapters that must be necessary to align the application programming interfaces that will be different between that source and destination. It just, sometimes it feels a little too easy to say, yeah, we should have a standard, so let's find a standards body and put everyone in that room and work it out. And sometimes that's not even possible. We've seen standards exercises with a lot of resources and energy go into them just fail. And again, I think it's still the right direction of travel, but I would have liked to see a little bit more in the paper recognizing just how hard that exercise is.
Thank you. Can I ask you one follow-up question on the data transfer initiative? Because it's hard as well, I guess, maybe not as hard as standardization, but how do you ensure that you have different view, I mean, and that you have all the view necessarily represented?
Well, I think that's the necessary exercise, is bringing the right people to the table initially, talking to people, asking everyone who you talk to, who else should we talk to, and then constantly iterating on outputs and processes, right? I think this is the same exercise the Commission has in developing its implementation of these laws in many ways, and the regulators as well. You need to recognize that the first step that you take will always be incomplete, will always benefit from further refinement, further discussion, and more perspective, and we certainly take that approach as well.
Thank you. Now I go to you, Audrey, so if you can again speak on one thing you like, what thing you don't like, but also I wanted you to speak a little bit about this new coalition of which Qualcomm is a member, so this coalition for open digital ecosystem, which is in a way the goal of the DMA, and so that's interesting if you can speak a little bit about what's the role of this coalition and what do you foresee also in the year to come.
Thanks, and very happy to be with you today. So first, I would like to congratulate Marc and Jan. I will concentrate more on the paper on interoperability. And I have to say that I was a bit annoyed by the instruction of like and don't like. Like, okay, I want to say what I want, but okay, but I really like the challenge. So what I like, and really, I like the report. I read it carefully last week in between working on organizing Davos, so a lot of drama, but trying to concentrate on this report. And I think it raised a number of great questions. I really like the way it was presented in a kind of professor way. Look at this example, A, B, C, D. I thought I knew a lot about interoperability, standardization, and messaging because I've been working a lot this year on it. And after reading the report, I'm like Jon Snow, I know nothing. But while I was reading the report, and that's the other thing I liked about the report, and I'm just going to give you a personal anecdote, then I go to the I don't like, and then I go to code. But over Christmas, I was in Brussels, preparing Davos, preparing a number of things. And I thought, it's the perfect time that we have code, that I'm switching ecosystem. It's Christmas, I have time. So I'm going to switch from one environment to another one. So I went to the portability, changing, making sure I have everything synchronized. And then I forgot something. I'm communicating with my daughter. She's 8 years old. You might think I'm crazy, but you will see. She's 8 years old, and she doesn't have a phone because I don't want her to have a phone. So she has a tablet, a special one. We used to communicate via iMessage. I moved to a phone where I don't have iMessage. So she started to send me cool stuff, and I'm not receiving your message. And then she said, but you work on phone, so how can you fix it? So I said, okay. I explained to her, this is a NIC, she's 8 years old, she gets it. But then I needed to find another app. And I started to look into what app I can have without having a phone number. And then I read Marc and Jan, and I said, okay. So you mentioned one app in the report, so I'm not going to make any advertisement, but thanks to you, you solved a family problem. So happy to tell you more about this as well, but really, so that's the first time a CERRE report is finding a family solution in the Scozzaro Ferrazzini family. So now we have the app, and we are testing it. And it's kind of interesting because, we were talking about education and digital native a little bit earlier today. But, I tried to teach her to be cautious on the internet, to not download everything. So I'm controlling everything, but at the same time, I can explain the value of security, the value of privacy. Moving to what I didn't really like. So it took me a long time. But page 27. When you talk, and it's interoperability versus innovation. It's true that when I read it, you are taking both sides. So you are mentioning the report from Fiona, and you're mentioning another report. So it's quite balanced. But I had to find something I didn't like. So I don't like the title. But in addition to that, just to be a little bit more concrete, I think that opposing interoperability and innovation is a little bit static from my perspective and for someone working at Qualcomm. Probably because we work in the mobile ecosystem and digital environment, and we are strong believer that, and maybe it's a little bit like a religion now, because I've been a decade at Qualcomm, I really embed the value. But the smartphone environment, and many people mentioned it earlier today, created a lot of innovation, myriad of innovation, but as well the fact that we can have the phone, we can download, most of the time now we can pay, we can do many, many things that before we're not able to do. We have our CEO, he has a funny picture, I didn't bring it, but he likes technology and all of that. But 30 years ago, you need to have a device to listen to the music. You needed to have a device to record, and so on and so forth. Basically now, everything is in your pocket. And you travel seamlessly, it works. So this Title, interoperability versus innovation. I don't like it. Sorry. On code now? So that's a little bit more on innovation. So just like for you to know that the first time I'm presenting code, I'm a member.
Could you recall what code is the acronym? Because
yes. So CODE stands for the Coalition for Open Digital Ecosystem. It is a new baby. Okay, that's a European baby that might be like international baby. It was launched 1 month ago, a very small baby, okay? We have 10 members, and I'm gonna mention them by alphabetical order. Google, Honor, Lenovo, Lynx, Meta, Motorola, Nothing, Opera, Qualcomm, and Wire. See a lot of letters from the alphabet. If you think about these two names, and we have more coming in the near future, but you have a kind of interesting balance, DMA perspective-wise. You have geographical balance, you have gatekeepers, you have non-gatekeepers, you have people benefiting from potentially some articles of the DMA, and you have people that are just curious about, what the DMA do. I'm going to mention the 4 principles, and after, I'm happy to answer any question because I don't want to be too long. So the principles are opening up digital ecosystems through cross-industry collaboration, promoting seamless connectivity and interoperable systems, all words very difficult to pronounce for a French woman, empowering consumers to choose devices and services with ease, and nurture an environment of open access. So a lot of openness. This organization is open. Anyone willing to join, they can contact any members. There is a website, and happy to answer, more questions.
Thank you very much. I mean, it seems to be that the objective of the DMA, maybe the Commission could join the coalition at some point.
Maybe.
Now we can go to Daniel from the CCIA.
Thank you, and it's a pleasure to be here today. I'm relatively new at the CCIA, only 3.5 months, so I'm a slightly older baby, but it's a pleasure to be here. And a little bit like Audrey, I just want to explain a little bit who I represent, because indeed a lot of the questions here are about gatekeepers, but our membership also includes companies from across the space, including access seekers, also companies potentially close to designations. So it's a really interesting mix of perspectives as well. And indeed, I've never had so much homework to do for a short panel before. So that was rather unusual as a dislike. That might be the first one, although it was also very interesting. And I have to say, it was really interesting reading. I'm sorry also, Audrey, that you're not in Davos after having spent Christmas preparing. But it's we have snow in Brussels today. So for me, I think the main point that I like also with my diverse membership is really that both papers actually point out the complexity of this and that there is no one right path, right? So different companies will be designated as gatekeeper and different services for very different reasons, and the solutions have to take that into account, and I think that's a very important principle. We see why we do need similar rules for similar services, but acknowledging that there are differences and taking that into account, and I think that's a critical point. And perhaps that was one of the other small dislikes in the papers, where it almost read like there had to be one uniform sort of approach on some of the things, and standardization does make sense to a point, but there can't be a uniform solution either, and I'm actually very curious to hear about you on that. I think if I'm looking at things that I liked, I think it makes the case very strongly that you cannot compel companies on the design of the business in certain ways. I think what Giorgio said at the beginning, to focus very much on process, not on outcome, is key. And I thought the paper mentions also briefly you know, the output indicators, and I just want to flag, for example, that I think in general for almost any company or sectors, that's probably not a good place to go, because an output indicator can be impacted by so many other things, and really it's about the process, and it's about creating choices for consumers, right? This is not about having an impact on market cap. It's not having a very demonstrable impact on user behavior, on completely changing user behavior on services. It's much more about giving that right choice. And I think both papers really highlight that on a very clear, factual level, which, you know, is not often the case to see something so clear. I do want to say on interoperability that, you know, the aim of the DMA really is that the interoperability rules broaden the choices for users, foster opportunities, but I actually don't agree with Audrey a little bit, because I do worry that it will impede the innovative capabilities of some of the platforms, and we do have to assess the impact on innovation, and indeed on security and on privacy, and we do need to consider some of the sort of distinct features of the markets and of the strategies. I think the papers could have even gone further in looking at those questions, but obviously there have been other CERRE papers on this, and it's relatively complicated. I do think trying to condense these discussions into also what the DMA is not is important, because too many of the discussions in the last few days as well in Brussels have been about many things that people think the DMA should be, but that's really not what it's about. And so, you know, I think it's a very exciting time to hear from you, really, where we are, where we're going, what the Commission is doing to prepare, what other types of experts you're going to be talking to, and indeed the outcomes on the 7th of March will be very different than in a year. Yes, exactly. One other thing I did want to say, because it was covered a little bit, is, you know, avoiding that free of charge, you know, is interpreted in too open a way, because we can get into that a bit later, but I do think that there are benefits to users from these ecosystems, and that just saying free of charge, opening it up too much, I think Jan and Marc, your paper was very good in showing that there are real risks if you don't limit. And then the final thing that I was a bit worried about, and it's also the nature of the fact that it's a more academic paper, is as a user reading the possible choices and applications of those choices that might be presented to me, I found it quite terrifying. So I'm really looking forward to hearing a little bit more about what it might mean from the Commission's point of view, because I think that some of these potential choices in trying to solve some of the things that the Commission wants to address, I'm worried that the solution might be overly complicated and damaging for consumer behavior and towards ecosystems in general and towards almost any company. So I'm going to stop there for now. But really, really impressive homework. So thank you.
Thank you very much, Daniel. Now we go to Chiara from so the French regulatory, Telecom Regulatory Authority, and from BEREC.
Thanks a lot. I really enjoyed reading the paper, so I will focus mainly on the interoperability paper because it's something that I am more competent on. I found it very informative and very instructive. It builds on another paper that I read last year, and I think on this one you really have like very concrete questions that you raise and you give concrete examples, so I really appreciated this. And I also found that the solutions that you were proposing and also explaining why one solution would be better than another one was very useful. And I also think that also like the technical workshop which was organized by the European Commission last year in February, and also the discussions which it raised and so on, it also gave you like some very interesting technical feedback and to build on, and it was very really much appreciated that you built on this and tried to see how the implementation could be implemented. It's a bit the exercise that we had to do at BEREC last year as well on the challenges, technical challenges for interoperability, so I understand like the pain in doing this exercise. But I think it really succeeded well in doing this. So this is what I really liked, and I also really liked, I'm sorry to say, but I also really liked the fact that you are presenting like what users may be confronted with, because it's actually, maybe now users are a bit passive, but I'm not sure that we should just stay with this and say, okay, they are passive, so let's keep them passive. Maybe it's just actually what we want to create is that they are more aware of actually of how, what is the architecture, the technical architecture behind, and how they can also actually influence the kind of service that they are enjoying. So I think it's actually very good to have this kind of approach and show what users can be, I mean, what kind of choices users can be given. So I will not go into the details of what I really liked technically, but actually I really liked that it was so technical and that it was really giving like solutions as well. Maybe I will just then go to what I didn't really like, but it's also there I had to take some time to think about it. And then I understood when I was reading, I was like, I'm a bit frustrating, something is missing, but I didn't see what right away, and then I understood it was the reference offer, because as a telco regulator, of course I was expecting like more analysis on like this technical reference offer, that it has to be prepared by the gatekeeper, and like what the implications, what kind of technical details should be there, how it should be updated, and so on. So then I was reading the paper on interoperability like a bit more as a standalone paper, so I didn't find it right away. But then I went to look for it in the report, and I found actually there were some elements about this. But maybe since some people are just interested on interoperability, may focus on just this chapter, maybe to just integrate some of the main challenges. Because I think, like for instance, in the updating mechanism is really key, because as Chris was saying, like the first time, you will probably get it, that's not, let's say, wrong, but not perfect. So the updating mechanism will be like really key. And I think it's something that should be highlighted, and also that it is also linked to the regulatory dialogue, which has to be set up, and it's very good actually that in the report to have a full chapter on the regulatory dialogue and how it can be organized and so on. So it's something that I also really appreciated. So yeah, so just on the reference offer, I think there are some challenges, and as BEREC we also published a report like defining and listing the minimum criteria which should be there in the reference offer. And then another thing is about, so you did it well in the presentation, so now I think that we agree, but in the report, for instance, there is a part about the challenges, which is opposing APIs and standardization, while APIs, I mean, it's not really, yeah, you see what I mean. It's not opposing, so standardization, it can be standardized APIs, but you present it as proprietary APIs, so in any case, I think we totally agree, but just maybe just not to create confusion. And then the last point is about vertical interoperability. On this, so at Arcep, we are big fans of these obligations, because it's something that we already worked on back in 2017 when nobody was talking about it. With a device, our work on device neutrality as well. So I'm really a big fan of these obligations. And I was a bit confused about some of the analysis that you are doing, especially when, for instance, you are mentioning the 3 criteria test. So as a regulator, of course, I'm happy to see that we can use some of our regulatory tools also in the DMA. But I think in this case, it's actually not really totally, I mean, I was a bit confused to see why we are mentioning it there, while the DMA is actually built in a very different way as some ex-ante regulatory process, also to avoid that there is this burden of proof, which sometimes it's lengthy and can actually be avoided in the case of the DMA. So in this case, I was a bit confused to see the references to the 3 criteria test and the theory of harm and so on. So that's all, I think. So congrats, because I really enjoyed reading it. I didn't do it over Christmas, but it was still a very nice read.
Thank you very much, Chiara. And now we go to Filomena. How is your reaction to what you have heard and also to the report?
Thanks, Alexander. I join the co-panelists in saying that it's very interesting and very enjoyable for us to read the report and all the papers. And if I focus, I will have comments on both papers, actually. So since we are working on across the board on different obligations, these two papers cover so many of them and with so many interesting intricacies that it will be also difficult for me to go into everything that the papers triggered when I was reading them. But if I start with the interoperability paper, I think one thing that struck me, and I say like this is finally we are discussing concrete elements of the interoperability in the sense meant by Article 7. Because we had long discussions on what interoperability is and how important or not important innovation. That's a bit of a slip also for me, like these are policy discussions that are behind us or ahead of us, but in the future. But at the moment, the added value that I found of this paper is really the concrete mapping of the issues that are relevant for such a discussion, for the interoperability under Article 7. And in this regard, as I said, albeit I could see some slips still into the theoretical issues around interoperability. At the same, another element that I also found very interesting, so with my colleagues, was the fact that there is a discussion of the trade-offs on what should the gatekeeper do, what should the access seeker do, because that's not a neutral element, and that has a big impact. And there I get to the more than what I don't have things I don't like, but things I would like to see more. Maybe that's the way of putting it. This is a proposal. The reference offer is in the hands of the gatekeeper. It's a different system than an industry-wide standard or interoperability. So what the gatekeeper might propose in 2 months, 1.5, has an impact in whether the offer is interesting for the user, for the access seeker to take. So how does this tension impact effectiveness? That's also an element that is relevant for the assessment of compliance. The same is so the dynamic angle, what is possible to do today, but then it would preclude innovation or adaptations that are coming in the future, that might also discourage take up of an offer. So it's another more dynamic form of effectiveness that I would argue will feed also into the reflections on compliance. And also how the different elements that you have identified, which are very useful and very important, how they fit into the concept of effectiveness. Because if the different challenges, you may have a wonderful spam filter, but not a good protocol. So how do you balance in the assessment of effectiveness these elements? So I'll say, and say my last point on Article 7, but actually that's a bit across. It's also in the paper on data. It's also in the other papers. Attention on interfaces and how users are nudged, triggered to accept things, to do one or the other things. We are paying, and we will pay a lot of attention to this. But then again, what is left missing, what are the behavioral insights that we can use in this analysis? There are several out there, but on interoperability perhaps not yet, because it's the first time on messaging system. So these were some of the thoughts that were triggered by the reading of the interoperability part. And one thing on the vertical interoperability. You heard it from Chiara. I had the same reaction when I went into the discussion on reading the discussion on Article 6, 7. like, where does this theory of harm comes from now, and what is the three criteria test of telecoms? I come from telecoms in my past, but so this was totally surprising, because actually, where is even the legal basis for this? Because I went, the text of the DMA talks about features that are available or used by the gatekeepers. And you mentioned, Marc, it presupposes a bottleneck. Yeah, it's called the CPS listed in the designation decision. So what other bottleneck do we need? So it's very perplexing that the papers, the second part of the paper starts on this, while there are certain interesting elements later on that are more in the logic of the DMA. So there is even like the fact that there have to be criteria for to qualify for the access, that they have to be clear in advance, that there has to be a process that can be assessed by third parties. There are different ideas which for me are in the logic of the DMA. So then it's really striking that there is this discrepancy between the first part and the second part of so the first principle in particular and the other four, in a way. So that's, let's say, the most perplexing part of the interoperability paper. On the data paper, okay, little anecdote. I will take 10 seconds of my time, which I've already, of course, gone over. A year ago, we were still in the process of hiring the staff. Now we are nearly full in the team. And I remember to one candidate, I asked the question, if you had to pick one provision in the DMA that you think is most innovative or most interesting, the candidate was like, oh, well, 5.2. I mean, no doubt. Of course, that person is in the team now. So other people would find 5.2 very confusing. At least a year ago, now we have moved on and we know much more about, or at least there have been a lot of reflection. So also thanks to the colleague who joined the team, being so enthusiastic about 5.2. So it's a very peculiar also provision in the DMA. So what in the paper, again, I find very, very interesting is the fact that you talk about what is compliance in concrete. So what are the possible options in your analysis? And I would agree with the paper that there is, it's left to the choice of a company how they organize their business model. That's the nature of the instrument, but within the limits set by the DMA. So if the DMA has set a limit that there shall be a less personalized alternative, there can be many alternatives, but one of them has to fulfill the less personalized but equivalent alternative. So that's but I think the paper focuses on how to achieve that, but there are different gradations, and there I have no particular views on how many of them the companies would have to offer. And actually, I think you made the point, there are so many different ways of complying, so there may be different proposals from different companies as long as the objective is achieved. So in this regard, so I also liked in the paper the terminology of data fusion. I will keep using it because combination and cross-use is too nerdish for normal conversations, I have to say. I don't know about data fusion. My favorite nerdish word I heard in the DMA is the Sherlocking, which, if I'm not mistaken, is what you call the data siloing. So I kept it. I like the term. To finish on this, I think if I to say what is that I would like to see more again in that analysis is the analysis of degradation, because if we are talking about a equivalent alternative, except for what really cannot be done without the data whose consent has been withdrawn, so what is acceptable degradation, what is unacceptable degradation? If you are asked, you make an example, if you are asked to pay for, instead of providing your data, Is that a degradation of the service, for example? So there are different questions that I think are still open, and we'll have to close, of course. But the very last point is the interplay with the GDPR. I mean, indeed, the DMA is not GDPR plus, but it comes together, it complements the GDPR. And I think it's also important so we refer in the DMA, we have to refer to concepts that belong to the GDPR. Explicitly, the DMA makes this reference. At the same time, let's also not forget that what is compliance under the GDPR is horizontal, is for every company and every individual. Compliance under the DMA is restricted to those that have been designated, and the tests are different, the objectives are different. So that's the framework in which we are analyzing and looking at the two. But of course, we are also discussing with the help of our friends in the DPAs, the protection authorities, how this interplay actually plays out in real terms for users and for gatekeepers. Voilà.
Thank you very much, Filomena. Now I will go to you, Jan. So you have heard several comments on your paper with Marc. So what is your reaction?
Yeah, thank you. Can you hear me?
Yes. Yes, we can. Yes, we can.
So at first I have to say that was sort of the nicest discussion and feedback round I've had at CERRE so far. So thank you very much for that. Yes, I mean there have been several things said. I think the most critical was on the sort of what we said, the 3 criteria test, and that it's too late and now to sort of discuss essentiality or which bottlenecks are there, and that through the designation of CPS that ship has sailed. I think we have to differentiate a little bit that an operating system is a CPS, but then the operating system is not monolithic. It's not providing one function. It's providing many, many functions, some of which is not even clear where the boundary is to the operating system versus, some app. You can carve out things from operating system to the app. So I think there will be a discussion, necessarily a discussion needed on sort of which elements of this huge sort of software system, operating system, are now accessible and need to be accessible, and which are not. Also because in the end, we are also thinking and talking about preserving innovation incentives of those that provide the operating system. So I think we would have to acknowledge that So I think this is where this is coming in. Whether or not, I mean, the 3 criteria test, I think we never put it as a definitive answer, but more as a starting point for discussion. And I also, of course, understand, and I also share this view that the DMA and the whole structure of the DMA is set up to have not lengthy litigation about any aspect, but let alone, I mean, you could also think of it as a principle of proportionality that kicks in anyways, right? And this was sort of our way, I think, of formalizing this a little bit in this particular context. And yes, I mean, that's probably the most, that was the most critical reaction, that I heard from the team so far. Other than that, I really appreciate the comments that have been made.
Thanks, Jan. Giorgio, maybe you want to react on what you have heard, and then if there is 1 or 2 questions, I will take them now, and then we'll finish the panel at 5 to go to the last one. But Giorgio first.
Okay. Thanks for all the comments. I appreciate some complexities weren't addressed, particularly in terms of standardizing the process. I think maybe the paper is a bit optimistic, and indeed, if you look at other sectors, it's real complicated. Just 2 responses quickly to Filomena's point. The fact that there must be one less personalized service is in the recitals, not in the articles, so it's not necessarily the law that there has to be, although I think it is the only practical solution. On degradation, I think it's true that it's difficult to know what it is, but to a certain extent, the way the DMA is phrased is, what is the status quo at the moment of compliance? And the degradation is from there. So one way of thinking about it is, what is the reasonable expectation of the user? And that has, because then that fixes a moment where you say, okay, what does the service look like before the gatekeeper changes? Of course, from there, that's just the starting point for analysis, but I agree it's completely difficult to work out.
Okay, so I see one question in the room. I don't know if you can give him a microphone. If there are anyone, I will take all of them at the same time. So if there is anyone else. Yes, James.
Good afternoon. James Thompson from Cullen International. What if users or some users don't want interoperability and aren't prepared to pay extra for it? Hypothetically, could Apple sell in Europe 2 versions of its iPhone? Could it sell one version of the iPhone that is not interoperable? So you can't sideload apps. iMessages won't be interoperable with other messaging services. The NFC chip will be closed, so you won't be able to use other payment wallets than Apple Pay. But consumers would have the choice of another version of an iPhone that is interoperable. A user could walk into an Apple shop or buy online and would have a choice of those 2 iPhones, one that is interoperable and one that is not, and perhaps the non-interoperable one might be cheaper. Would that scenario be compatible with the DMA?
Thank you. Filomena, what's your view?
I would say why. First, why would the user have to choose ex ante? Because they can always choose to not use interoperability. That's something that you can do. It's, I mean, that's also something, the DMA gives opportunities. It doesn't oblige to interoperate, neither under 7 or under 6.7. So neither the business user nor the end user are obliged to make use of that function. So I'm struggling to see what could be even the added value of such a scenario because it would be cheaper, you say. In any event,
I would allow you to relaunch the question because let's do it bilaterally.
Because interoperability might not be cost-free to the gatekeeper.
But I suggest you discuss that at the cocktail.
Anyway.
Other question or yes, and the last question, but quick question, then we close.
Isabella De Michelis. The question is for Filomena. So you talked about the importance of the horizontal regulation, GDPR, and vertical regulation, DMA. One applies to everyone, the other applies only to some. Then we know that we have the business users with this incredible long list of people who would like to have access to this data from the users and with the permission of the users if they're personal, and maybe not the permission of the users if they're not personal. Now, how does it play the DSA provision about dark pattern to the business users if they want to capitalize on the ease of access of the data of the gatekeepers by actually applying an interface that actually it's nudging their consent rather than really convincing the users to do it? Thank you.
Well, I mean, the easy reply is Article 13. I mean, using dark patterns is considered circumvention. So that's non-compliance. By non-compliance, not directly, but indirectly. But also, because you made the point before, I think, if your business users are interested, I think Chris is there to, I'm saying because this happened in the workshop, people going to him like, hey, can I make use of your solution? Or there are business users there that are starting to see what's coming up of the DMA and what they can do with it. Data portability is one, interoperability is another one. Actually, the provisions we are discussing today are really some that have triggered the attention. And I refer to what Martin announced this morning, the conference or the gathering that is meant exactly to raise awareness of the business users for the DMA. That's also something that is going to happen. But for the dark patterns, I think that's, I think we have it covered. We have it on our radar, and it's in the law is covered.
So if I understand the answer, I just want to be sure that I understood the answer. The answer is that there will be an oversight that dark patterns will be prohibited on business users that would nudge the users if it is for the sake of data portability that may not be wanted by the users. The question is really on the business users, it's not on the gatekeepers, sorry.
That's okay, that's out of the DMA then. That's Yeah, okay, but I'm not in charge. So.
Again, I mean, that's a good discussion for the cocktail. So many thanks to all the panelists for this one, and then we move to the last panel before the keynote on choice architecture. So thank you very much.